Yeah.
Donna, let's hear from Donna. Donna, you're on WSJS and Mike Wells. Good morning.
Good morning. How are you?
Okay.
I had a question. You ready for me to shoot it out?
Go right ahead.
Go ahead.
You're on with Mike.
Okay. My question is, if we have a will and we had inherited some money from a will and it was set up in a trust, is the bank that's the trustee required to give us 5% a year off of the net?
Well, it depends on what the trust says. There are some trusts that are set up for that, for like a spouse, that for tax planning, but it just depends on what the will says. And the trust in the will, called a testamentary trust, your last will and testament, that's why it's called a testamentary trust. Testa comes from that Latin talk, testify, to speak. So your last statement, if you will, that's where all that comes from. But if it just depends on what the trust says. If the trust says you're supposed to get 5% of the principal, what's in the trust, annually, irrespective of anything else, then that's what you get. But the terms of the trust will give you either a specific objective measurement about what you're supposed to get, or it may be completely discretionary. It may be that the trustee makes it on their own decision. So you really have to get the trust to be reviewed to see what it requires.
Okay, if it's really not clear. It doesn't say 5%. I was just told that they are at least required to give us that. It is set up to where it's kind of hard to understand. It's just been a big mess with the will, but it's hard to really. It's not really clear. It's left up to the discretion of the trustee, which is the bank.
Right. I think what I would do probably is get a lawyer to review a copy. You can get a copy of the trust, can't you?
Yeah, we have the will.
Okay. Well, you can. I'd have a lawyer look over that to see what the lawyer thinks about what's required.
Okay. Can I ask you one more question?
Sure.
If you have, if you're filing a caveat against a will, and there's another party that is supposed to inherit something. I don't want to get into explaining the whole will because I know you don't have time for that. But if another party is supposed to inherit it after a certain person's gone, like if the money's set up, like for my husband, and then after he passes on, what's left goes to, let's say, a church. If we're trying to file a caveat against it, does the other party have to, like, does the church have to file the caveat also to get it stopped and be in agreement, or how does that work?
Well, generally, you have to be a party that would be impacted by what the in other words, if you say this new will was not right, it wasn't executed properly, someone was under distress, coerced, they didn't have their mind about them, and if we kick this will out, then I get something. In other words, you have to have a reason. You have to have a vested interest that says I've got a stake in what happens with this estate. So it depends on what the circumstances are, and basically for you and our listeners, a caveat is a legal term that means you're challenging the will. You're saying I'm saying this will was either not executed properly, the person was coerced into making it, and therefore it was not their own mind, so to speak, or they were not competent. They had Alzheimer's. They just didn't know what they were doing. And so as a consequence, this will is not valid. Then once that will is kicked out, if that occurs, then you get revert to whatever the other proper will was, if there is one, and then if not, the will that the state of North Carolina writes you. So you really probably need to sit down with a lawyer that deals with those kinds of cases to see what the will says, and really to assess those circumstances. Those kinds of cases are sometimes difficult to prove because you've got to establish something. The main person is dead, about what they thought or what they didn't know, et cetera. So you have to reconstruct, but they can be challenged.
But I guess what I'm trying to ask, like, if we do file a caveat, and does the church have to be in agreement, or can we file it without them?
If you've got if you're an interested party and you have a vested right, then you don't have to get everybody else to agree on it.
Okay, that's what I was.
You have the right to say, well, hey, I've been adversely impacted because if this will was not in existence, I would get, something under the old will or under the law.
Well, we were told that if the church would agree to just drop it because they are mainly the main inheritance from the will, because it's made to where my husband only gets money if he's destitute, and we don't understand it all. There was
Well, you can have a so-called family agreement or an overall settlement that says we don't know, there are issues, and so the law, in fact, would encourage folks to sit down and say, rather than getting into a real expensive duke out on which everybody spends a lot of money in attorney's fees, the court's going to want to encourage folks to try to resolve those issues. So
that's what we were trying to do.
Folks can resolve, and that clearly, obviously depending on the terms, but folks are much better off. These if you get into challenging a will, if the will is, you don't even have to be successful as long as your challenge is not just frivolous, no basis whatsoever. Once whatever happens on the wills, both sets of attorney's fees are paid out of the estate, you see.
Oh, okay.
So, well, you can spend a lot of money on lawyer fees, or you can try to resolve things in a reasonable manner and say, let's get more dollars net. The more net dollars you have to divide up, the easier it is to make the pot right, if you will, to settle it. So yes, ma'am, you can work it out, and certainly churches and other nonprofit organizations, they're not picking a fight for something here, but I would encourage folks to try to resolve those issues.
Well, what I was trying, you're hitting right what I was needing to know, but see, what we were going to talk to the church and try to work it out ourselves, and then maybe give them a certain amount. But
right.
The lawyer that messed all of this up said that they would the only way to stop the will was we would have to file a caveat and the church would have to file a caveat. So we didn't know how true that was, or if that's true or what.
Well, I'm not saying that that's not, quote, true, but I do, you have to have some sort of something that's filed that gives the court some province to resolve the matter.
Let's talk to Mickey. Mickey, you're on with Mike Wells. Good morning.
Hello. I have a question concerning the gift tax. Could Mr. Wells explain, I've heard something about recent changes in the state of North Carolina. Can he explain what the changes are and how it affects people, whatever they are?
Yes, ma'am. That's a good. All of these are good questions. The legislature passed a law that's effective, I believe, January 1, 2009, and just a few months here now, 7 months, 6 months from now, where as I understand it, the gift tax is gone. So before, under the present, in terms of the state gift tax, for example, under the federal law and the state law, you can give anybody up to $12,000 a year without any questions. When you start giving more than that, then you get into some potential gift tax issues. Under the federal law, in addition to the $12,000 a year to anybody for any reason, you have a lifetime exemption while you're living of up to $1 million. So, and it's irrespective of the people to whom you want to give it. So, if you wanted to give, $50,000 to your neighbor, you could do that, and you have to file some returns. But essentially, the net effect would be you would not have to pay tax. Under North Carolina gift tax, that you can give up to $100,000 lifetime if it's your children or some other, limited exceptions in terms of family. But if it's not going to a family person, or if it's over this $100,000 and it doesn't apply to that, then you have some gift tax issues. So this law is a pretty good change for folks who want to give gift property while they're living, but it's effective on January 1. So
okay.
Do you have an accountant or CPA with whom you work?
I do for tax purposes.
All right. You might call them. They're going to be more versed on, the particular ABCs, but that's the gist of it. It was just passed here a few weeks ago, but it is effective on January 1. So if you're planning on making any gifts, then I would encourage you to call your CPA, your accountant, and they'll give you the ABCs they'll fill in some of the details from what I've given you, but that's the gist of it. The law's changing, but it's effective January 1.
Okay, and will it eliminate it on January 1?
Yes, ma'am, that's my understanding. I haven't seen the actual galleys of the laws, but my understanding is that effective January 1, the gift tax in North Carolina does not have those limits. Now, you still have, the federal government, of course, still has that $1 million. For example, you would not be able to give over $1 million to JR and me. You'd have to pay some gift taxes.